My Lord, within 7 days from receiving this resolution from the National Assembly, my Lord, the Speaker of the Senate is supposed to commence action, proceedings towards the completion of the removal of, or otherwise, of the Deputy President. My Lord, to consider the motion, my Lord, to commence the proceedings to consider that motion for the removal of President stroke Deputy President. My Lord, thereafter, they only have 10 other days, my Lord, 10 other days to finish the process, to make a decision. My Lord, you can correlate this to Article 140 of the Constitution of Kenya, which requires that a petition once presented to the Supreme Court for the validity of a presidential election must be determined within 14 days. So, my Lord, it's not unique for these proceedings to be determined in this manner. My Lord, there are constitutional policy reasons why that is the case. My Lord, perhaps because this position is important and stability of the nation is very critical, you don't want to keep people in abeyance on who is their president and deputy president. My Lord, the deputy president, when there's a vacancy in the office of president, they're supposed to assume office as president. So, my Lord, because of these constitutional timelines, then one of the reasons my Lord, can make is that because of the stability of the nation, you cannot have a vacancy in the office of president and deputy president within this kind of periods. That is why the Constitution, my Lord, has set strict timelines for determination of questions concerning their removal from office or election into office. So that, my Lord, this is now tied on the public participation. So that, my Lord, what happens on the public participation, my Lord, is that whereas public participation is not provided for in Article 64 of the Standing Orders, my Lord, public participation is a constitutional imperative which so many authorities have laid down, and including this court, my Lord. So that, my Lord, this constitutional imperative known as public participation must be done within the confines of the timelines which have been laid down. So, my Lord, the National Assembly was required to do public participation, my Lord, within those timelines and not create excuses. And my Lord, that's what the National Assembly did, public participation within the constitutional timelines. My Lord, submissions was made by Senior Counsel Paul Muite on whether a response by the Deputy President is needed when you are going to public participation. My Lord, in my view, that is stretching the issue too far. My Lord, what is before the House of the National Assembly is often a motion. And my Lord, the Constitution talks about a motion for the removal of Deputy President. My Lord, that motion, before it is determined, public participation must be conducted. So, my Lord, the obligation of Parliament is to ensure that that motion goes to the people, for them to air their views on what they think the motion, on what they think the elected members should do with the motion. And my Lord, it is important to mention that sovereignty, they exercise it directly or indirectly through their elected representatives. So, my Lord, there is no obligation whatsoever to send a response to the people, because by that time, there are no proceedings contemplated in the standing orders for pre-impeachment public participation, because there is no motion. It will be speculative to go to the people with a motion which has not been introduced to the House for adjudication. Just like this court cannot adjudicate, my Lord, on a petition which is not before it. People will be talking to the media about the petition, but the High Court will only be seized of that petition when it is brought before it. My Lord, that is very important to to distinguish. And my Lord, the efficacy of or adequacy of this public participation my Lord, because it was done, cannot be considered at this stage of the proceedings. My Lord, the petitioner is inviting you to make conclusive determination on the question of public participation. My Lord, the response from the National Assembly that public participation was indeed done, and the mere fact that it was done, then, my Lord, you cannot consider that on merits at this stage. So, my Lord, we urge that you don't grant the conservative orders. So, my Lord, the application of the conservatory orders will to destabilize the process which is before the Senate. My Lord, there is no timeline, there is no guideline on what happens when the court has issued conservatory orders. What happens to the timelines in Article 145? What happens to those timelines when conservatory orders are issued? My Lord, the doctrine of proportionality in the Mutunga rules require that you exercise some restraint as not to issue conservatory orders at this stage. My Lord, Senior Counsel Paul Muite talked about gross violation of the Constitution as one of the grounds. He says the motion does not meet the motion for impeachment. But, my Lord, again, in the Sonko case, the Supreme Court has said the role of the court is not to look at the merits of these allegations. My Lord, instead, the High Court is supposed to just look at the process issues. Has the National Assembly complied with the standing orders and the provisions of Article 145? My Lord, if the answer is yes, then, my Lord, you allow those proceedings to continue and conclude. My Lord, now that my colleague, Senior Counsel, talked about gross violation of the Constitution, my Lord, allow me to say that indeed, from the motion, the Deputy President, there are serious allegations that the Deputy President is facing. And, my Lord, as I wind up, my Lord, the Deputy President is participating in the proceedings before the Senate. My Lord, that is important. He is participating in the proceedings before the Senate as we speak. So, my Lord, he cannot approbate and reprobate. He cannot participate in the proceedings before the Senate. My Lord, yes, my Lord, the process is going on. My Lord, allow me to quote a document, my Lord, which, because I'm not speaking from the bar. Yes, my Lord. Yes, my Lord. From a response which was filed, which we have filed, and which also my colleague have filed, my Lord, an affidavit, supplementary affidavit by regarding Gachagua. My Lord, this is what they have annexed. My Lord, they have annexed a letter from the Senate inviting them to submit a response by 5 p.m. today, stating that the motion is before the House. They were given material which constitute this motion, and they were required to file a response. My Lord, under Article 145 of the Constitution, those proceedings have already commenced. My Lord, what I'm saying is that the 10 days for the Senate to consider that question have already commenced. The proceedings are active before the Senate. Yes.
Not the document that was filed.
That's correct, my Lord.
So can we explain ourselves to that point?
Okay, my Lord. I'll rephrase then, my Lord, by saying that the Senate has invited the Deputy President,
that's fine.
Yes, to appear, my Lord, before it to answer on these weighty allegations which the petitioner says concern gross violation of the Constitution. My Lord, now that brings out a fundamental point. My Lord, he has opportunity in accordance with the provisions of Article 50 of the Constitution. My Lord, he has opportunity to air his grievance in a trial process at the Senate. My Lord, that's a fundamental tenet of the doctrine of natural justice. He has been given an opportunity to come and ventilate his concerns about public participation, about the content of their motion, the allegations he is facing. He has opportunity to ventilate those concerns in a quasi-judicial process, my Lord. My Lord, quasi-judicial process. So, my Lord, it's better that we allow him to exercise his opportunity to appear before this quasi-judicial process for the trial of these allegations. My Lord, the issuance of conservatory orders will deny the parties that opportunity to subject the allegations against him in a constitutionally tested and compliant process of impeachment. My Lord, the senators act as jurors, as in this case, stroke judges. My Lord, they are required to make up to decide on each and every allegation that he is facing. So, my Lord, the doctrine of ripeness then applies against the deputy president at this stage of the proceedings. My Lord, his complaint is not ripe for judicial adjudication yet. My Lord, as I wind up, the roof is not on fire. My Lord, the courts of the doors of this court have not closed at him to come and ventilate his concerns about the entire process completed. But after the impeachment proceedings have concluded. And my Lord, this is the tenor and the effect of their submit in petition 522 of 2024. Whereas conservatory orders were sought, they abandoned the quest for conservatory orders in 522 of 2024. My Lord, the questions concerning public participation have been certified as raising substantial questions of law in 522 of 2024. My Lord, there's a prayer on arresting, suspending, or interfering with the decision of the Senate in 522-2024. And my Lord, those proceedings anytime now will be before a three-judge bench for adjudication. My Lord, to the extent that that prayer is live, in procedure actively pending for another bench, then in these proceedings, they will be doing what we call lemon selling. If they seek conservatory orders, these proceedings, they'll be doing what we call lemon selling. My Lord, I request a case and pray that you don't consider granting the orders for conservatory orders at this stage. Indeed, my Lord, if there's any decision with respect to consolidation, my Lord, we concede that this petition can be consolidated with petition 522, my Lord, for good order, my Lord, so that there is no conflict in terms of decisions which are made by the High Court on the same subject matter, my Lord. My Lord, with respect to the same petitioner, my Lord, the same petitioner. Thank you, my Lord.
Yes, my Lord. Yes, I have my time.
Ask a question.
Yes, my Lord.
You refer to paragraph 93.
Yes, of the...
Although I understand what is
Yes. The flip side is that these standing orders then enjoy the presumption of constitutionality, unless they are impugned and a case made. Because at the time, for example, at the time of processing this motion, this was the standing order which was applicable. And therefore,
Again, I just wanted to understand.
yes, that's correct, my lord.
Thank you, my lord.
You want to have 30 minutes.
I'll try.